Thank you very much. Good morning, everyone. All right, we're here today in the matter of State of Florida versus Michael Edward Keetley. It looks like everyone, including Mr. Keetley, is present at this time. This case is set for sentencing today as a result of the trial and the jury finding Mr. Keetley guilty of all counts. There were some motions that were filed. I have those motions here, a motion for new trial, as well as a motion for renewed judgment of acquittal. So we will need to address those first. Is the defense ready?
Yes, sir.
Is the state ready?
Yes, Your Honor. And Judge, we do have the majority of our victims here. I just wanted to let the court know we were informed that 2 other victims do intend on speaking. I believe they're en route, but we can go ahead and proceed with the motions.
All right, are you sure?
Yes, Judge.
Okay.
And I have an investigator just checking to make sure how far away they are.
Not a problem. I will wait. You know, we will absolutely give them an opportunity to be heard, but I agree. I think we should probably go ahead and start with the motions.
Yes, sir.
Okay, thank you very much. All right, so I bet. How about this? How about if I just have everybody state their names for the record, since we have a court reporter and there's some media present. We'll just go ahead. I'll say it on the state side and let everybody state their name for the record.
Michelle Doherty.
Jennifer Johnson.
Richard Escobar. John Grant.
Denise Sokolev.
All right, so those are all of the attorneys. And as I said, Mr. Michael Edward Keetley is also present at defense counsel with his attorneys. So who's going to talk about the 2 motions that have been filed by the defense?
I will, sir.
All right, Mr. Grant, let me hear what you have to say. I will let you know that I have read, actually multiple times, both motions, so I am familiar with everything in it, and it does appear to be a lot of stuff that was heavily litigated throughout the course prior to the trial and during the trial. They are well written. Did you write them?
No, sir. That's why they're well written.
I understand. They are very well written. But I am absolutely at this time willing to hear anything additional or anything that you want to point out in either of those motions. Is it all right? Should we do them separately or together? How do you prefer to do it?
Well, I was going to ask how you prefer to do it, because a lot of the same
the stuff is the same.
Right? So if I'm arguing or answering questions from you, it's going to apply to the motion for new trial and judgment of acquittal.
Let's try to do them together as much as we can, but
okay.
If there's any discrepancies that you want to, based on different burdens or anything, I'll allow you to point those things out. But I agree, the factual basis in both is almost identical.
Right.
There are some different things that are raised ultimately, but they overlap to some degree.
Right, and one standard in the motion for judgment of acquittal, I'm being a little glib when I say this, that rules of criminal and appellate procedure basically allows you to sit in the role of the 13th juror, as opposed to the motion for new trial, which is more on the issues of
errors.
Correct, and so I'm pleased to address as you will. Let me go ahead. All right, cool. All right. Well,
The stage is yours.
thank you. Well, good morning, State, Mr. Keetley, Your Honor. So let me start the idea back on a schoolyard playground when we would play baseball or football, and one of the kids who's better than us would score a touchdown or hit a 3-pointer or something like that. And we would say, no fair, we want a do-over, right? A lot of times, as kids, we just didn't like the result, okay? And sometimes it can be seen that this is what this motion is. We just don't like the result. It's unfair. We want a do-over. But we're not talking about unfair in the sense that we would on a schoolyard playground. We're talking about procedurally. Last night, I happened to be sitting with my 11-year-old watching a little bit of a baseball game, and there was a replay. And he started talking about replay and why that matters. And we were talking about how sometimes a good umpire, a good referee, can make decisions in the heat of the moment and try to do the good and the right thing, but yet further review says, we need to take a look at that. And here's a guy who was tagged out at the plate, who was called safe originally, and it changed the game. They couldn't let the game go forward because there was an error or a mistake, not one of intent, but there was an error or mistake that required that portion of the game to be replayed. And that's kind of where we are in the sense of the motion for new trial, dovetailing that in the motion for JOA. I think the court remembers. I know it's been a while. I know the court has sat through a ton of hearings and 2 trials. A court may have an idea of my opening statement. I'm tempted to give it again. I know the court won't let me, and I'm not even going to try. But in essence, the theory of our case was Michael Keetley did not do this because he could not do this. He was not physically able to do this, right? And so that was a linchpin of our argument in the case.
That's not exactly what your expert said, though, in the end on cross-examination.
Well, I would disagree with that, because the cross-examination from the state assumed things that may not have been true, or not have been true. Let me state that a little bit better. They assumed things that did not comport with the facts at the time. For example, when Halpern was asked, could this have happened? Could this have happened? Yes, it assumed in that case that the shooter was in a stationary position, when clearly the evidence showed that the shooter was moving at the time, right? And so there were some distinctions drawn by Dr. Halpern, and he agreed with Ms. Hodges' cross-examination in the sense that she placed it at times, but that was inconsistent with the evidence, right? So I would still argue that our thesis and our mission statement, for lack of a better way to put it, still does hold, right? That he did not do it because he could not do it. He could not physically do it. And that ties into the issue of the gun modification that's been argued time and again and is in both of our motions here. The gun modification deals with the fact that every witness, whether they could make an identification or not, and I understand I'm going to say something and you're going to push back, and I get it. This is like a circumstantial evidence case, and I hear you already saying, but wait, did we not have 2 people make an identification? I understand that. I'm saying like a circumstantial evidence.
There's a lot of circumstantial evidence. I don't disagree with you.
Right, and when we talked about the identifications, there were varying heights and weights that Mr. Keetley has never been in these identifications. So the circumstances become more important. And when the state could not and did not have an answer for the fact that every witness said this was a black pump action shotgun.
But we know it wasn't a shotgun.
Correct. But that's what the witnesses said. So that's where the gun modification was allowed to be presented to the jury. In fact, it did get limited. We know that because the expert that they flew down from Pennsylvania at the end rightly said, hey, what I said I could say. He
couldn't narrow down the time frame.
Well, he thought he could, right? Just to not remind or correct, but he thought he could based on a advertisement that came out, but then the advertisement, looking more closely at it, did not give him the opportunity to say that conclusively. So we're pleased that he stayed true to what he said in his deposition. He said, based on this, I cannot say that. So that was the only reason why that didn't come in. But we were almost to hear and see about Aroni, and there was no evidence at all of Aroni. And I understand that when they say it was a black pump action shotgun, all these witnesses, and we know that it was not, now they were able to try to make a theory based on no evidence, no factual basis at all, that this must have been how it occurred. And there was no evidence to support that, right? So when we talk about that evidence coming in, we talk about this issue, and I put it in, we put it into motion. We start with 90.401. We've done this before. Relevant evidence is defined as that which tends to prove or disprove a material fact. 90.402. All relevant evidence is admissible. Then we get to the kicker, 90.403. It talks about prejudicial evidence. Okay, but hold that ticket stub, because what it does not say is prejudicial evidence cannot come in. The state prejudices us all the time with evidence that tends to prove guilt in their mind. We prejudice back on cross-examination. There is evidence that hurts or prejudices. The issue is dangerous and unfair prejudice. And does that dangerous and unfair prejudice outweigh the probative value?
Outweigh? Is it outweigh?
Yes,
Is
absolutely.
there not another word in the statute?
I think confusion of the issues.
Substantially.
You're right.
Isn't that important, though? When you say, does it outweigh, is a completely different sentence than saying, does it substantially outweigh? And defense attorneys leave that word out all the time. Well, and the state, to be honest, both sides. Whoever's opposing the evidence as prejudicial argues that it outweighs. And it's not just that it outweighs, it's that it substantially. That's a big word. That's a strong word.
And that's an appropriate word based on the evidence that's here. I agree with you. Substantially outweigh. Way back in law school on the trial team, they made me try to remember the 90.403 language, and I still struggle with it, right? But yes, does the dangerous and unfair prejudice substantially outweigh any probative value of the evidence? And I'm going to say whatever argument, and I know there's not an argument about the proper wording, I agree with whatever that statute says, substantially outweigh when we are able to put before a jury as a prosecutor evidence of a modification, evidence of here's how this might have been done without any substance to it. There's the word substantially coming in on the other side. What substance was there to say that there was actually a RONI use or a modification? I get that the conclusion may have been there, but we don't get to convict on conclusions. We shouldn't prosecute on theories without evidence, and that's where we're coming from for both the motion for new trial on this particular issue and the motion for judgment of acquittal.
But the basic facts here are that the witnesses testified that it was a shotgun. The evidence at the scene, including the cartridges, the bullets in the victims, so the medical evidence was that it was a .45 caliber handgun.
Right.
So those two things, there has to be some explanation for that.
Well,
it wasn't a shotgun.
Well, maybe you deal with Occam's razor, and that is that the simplest explanation is one that makes the most sense. And a modification of a RONI or any other type of device that may or may not have been out on the market at the time is not the simplest explanation. With respect to these victims, and I want to make very clear, whether they were drinking, using drugs, or whatever state of intoxication they were in that night does not justify what happened to them, okay? In no shape. And I'm not taking a character situation on them. But we heard from these people that they were in various states of intoxication. One didn't even bother to show, and we don't even know really where he is at this point in time. So he testified by TV. That being said, when you have various states of intoxication, why is it not that they just got it wrong and the shooter actually had a .45 handgun without a modification? There's no evidence that there was a modification. They're just trying to explain what happened through the eyes of people, as we recall Jennifer Dysart's testimony, a sudden event in dark circumstances. It's quick. There's potential cross-race.
Just as likely and reasonable that they got it wrong and the shirt said sheriff instead of police.
No, because that's where we can't have our cake and eat it too, right? We can't say, oh, we agree with that because that fits in our theory, and we disagree with that. In fact, what I would argue is that what these victims in their own way said are wholly unreliable in the whole, right? And so you have to look at and address it. Sheriff and police are two totally separate, distinct words. I think it was Mr. Beltran.
Shotgun and handgun are two different, totally separate things.
Correct.
Firearms.
But they're not in and around the same type of size or thing, right? A water bottle and a Coke bottle could be separate things, but they're about the same size, similar in shape. You can't say that about a handgun. You can't say that about a shotgun. You can't say that about the word police, and you can't say that about the word sheriff. These are totally separate things. And in fact, I think it was Mr. Beltran who said that not only did the word say sheriff, it said security on the back. Okay? And there were yellow letters. That's going to take me, we might as well go there now, about this picture that was allowed to come in that had no bearing at all into this case. Michael Keetley at a Halloween party, and I underline, bold, and raise the font level to say Halloween party. He's wearing a police shirt. Okay. Now we had Norma Towers come in and testify, and there was some suggestion that we had to cross-examine her. And glad to do it. And we had to point out to her that, for example, she said something about a blue shirt that may have said police, and then when I got the chance to ask questions, what did we hear? We heard, oh, well, maybe it was in the laundry, and I may not have seen it. There was nothing anywhere at all to suggest that Michael Keetley had a police shirt, Michael Keetley had anything involving a sheriff uniform. But we had this picture that came into evidence somehow to corroborate the victim's testimony and to suggest that he's dressing up as a police officer. Okay? People have dressed up as police officers or other types of things at Halloween parties since time immemorial. Okay? The point of that is we can't figure out what that has to do with the facts at hand of what happened on October 31st. Actually, not October 31st, November 25th. All right? 30 days beforehand. Okay? This is an unfortunate set of circumstance that Michael Keetley happens to pick out a Halloween costume, and then, 30 days later, someone having some type of similarity, apparently, has a uniform that's really not even similar. And by the way, don't forget, when we talk about this idea, the shooter, whoever he was, somehow tied up boots, because that's what they said was involved in this case. This man can't even tie his own shoe. We put pictures before the jury to show that he has slip-on shoes. Even Miss Towers, I believe, said he was using shoes that would Velcro or lace because he couldn't do that, right? And the boots that they took a picture of didn't have any trace element at all of blood or any other type of fluid or DNA that would be expected because the shooter walked throughout the porch. He walked through everything as he was doing what he was doing. None of that evidence was present for Michael Keetley. Not one bit. And so that's why we say when we take the picture, in some regards, I'm tempted to argue that it's like the death of 1,000 cuts, right? And it's cumulative, it's cumulative, it's cumulative. And I was thinking about that last night. I said, no. When we're talking about the police photo, this is not cumulative. In a case that's terrible, and it's had an impact on this community, okay? And I was thinking through that. All the people who've been affected by this case, from victims to prosecutors to police to defense attorneys who stand here now, from defense attorneys who stand in the present, some of whom have passed away. This is a big case, right? And Michael Keetley has been accused, and I want to say this so it doesn't come off disrespectful, sir, because I respect you.
I won't take it disrespectful.
Thank you, sir. I respect it. We allowed a jury to see a picture that said police as somehow being evidence that the man who does not fit Michael Keetley's build, who does not fit Michael Keetley's weight, who does not fit Michael Keetley's height, none of that. And we allowed a jury to see police when it was actually sheriff. We allowed him to see white lettering when it was actually yellow. We allowed him to see a shirt that said security on the back, right? Gonzalo Guevara, in his statement, talked about how the person came up with whatever this black pump-action shotgun was, and I'm using the description here, and somehow he had that in the left hand, and a badge-like thing was in the right hand. I may have the right and the left mixed up, but in any event, the point is that somehow Michael Keetley, who cannot use, and this goes back to Dr. Halpern, and this goes back to the limited questions that Ms. Hodges was asking. You have to take him in his whole, that somehow Michael Keetley, who had trouble walking steadily, was able to get out of that car, come, switch from the right hand to the left hand so that the badge gets put down, and now he can use the hand that doesn't work. He's a one-handed man, okay? And that was the whole point of Dr. Halpern, that the way this was described could not be done, right? And so it's the same thing as we talk about the trash. I don't know that that's necessarily a feature in the motion, but that was one of the motion in limine that I talked about, and this helps give you one of the areas of the themes. That when Mr. Keetley went the next day to Henry Boa's house, and there was 2 bags of trash, okay? You asked me, and I can't remember how you phrased it, but it was well phrased. You said, hey, is this fact true? Is this fact true? You went to like 5 facts. Can the state argue that? And I said, absolutely, but that didn't allow for the 6th, right? That I have no problem fighting the state, you know, in the sense of a trial and doing this process. I don't have a problem fighting them, but they should be limited to their theory of prosecution on admissible evidence, right? And so that's one of the things we argued to them, that certain things can be true. That they argue that he went to Henry Boa's house the next day. Yes, yes, yes. But when we allow them to argue, well, there were 2 bags of trash, and so therefore there must have been evidence that was disposed of at this time. There was simply no reason or way to draw that conclusion, right? And so these are things that I would say in the cumulative, in addition to certain things that in and of themselves. This police shirt, let me tell you, off the charts. This is a big deal, right? And it allows a juror in what is largely a circumstantial case. I get it. There are 2 witnesses who made an identification. And I think we can concede that factually there were questions that were asked that would call that identification in question. And I'll concede that they're the trier of fact. And they get to decide that. I understand that. But when they're aided by evidence that should not have come in, it's going to push them in a certain way. You know, and that's what I think we're trying to say in our motion here. That if you want to prosecute, do it. If you want to prosecute with all your might, do it. But let's do it by admissible evidence. And there was a point that the court had, I think you'll remember, I think week 1, they all blended together. We had a lot of argument. I don't think I was the one who made that argument. I can't recall, but Ms. Hodges was on the other side. The issues of the cloth and the burn pit, right? You went through the 401, 402, 403 analysis and made the decision that it would not come in.
Right.
That's the same thing we're talking about here. I know throughout this time you're engaging, asking questions of me and my team. You're asking questions of the state and their prosecutors. And we've tried to compare at times, and I always argue that all analogies break down. But that same analysis that kept out the burn pit, when they really wanted to try to say that this piece of cloth had to be attached to a black shirt that said police, and that there was just no there, and we respect and agree with your ruling. It's like we respect your rulings going through the process. We just disagree with how you got there on the police shirt. You know, and one of the things I think it goes without saying, I re-urge, and I know this court did pay attention, and I think in your opening comments this would be what you're saying, that, you know, all the arguments that were made, going back to Paul Carr, and then Leanne Gowdy, and then Deanne Nathan, and all that have come before me standing here, I re-urge all those arguments because a couple of those people, maybe all of them, are better lawyers than I am. And they are probably more articulate than I am. And so they may have said it better than I did. But I'm standing here at the precipice where this man is about to get life in prison unless we grant this motion that respectfully should be granted. Whether it be the motion for new trial or the motion for judgment of acquittal. This jury, I guess in sum, and I don't know if you have any questions, but if not, I think I've wrapped it because we have had months to argue. And you know the arguments. Well, this jury decided, whatever they do, and I want to say this correct, we have a process here, right? And they bring a verdict, and we accept that they brought a verdict, okay? But this motion says, hey, they brought a verdict that we don't agree with, and it's more than that. We're not looking for the do-over. It's they brought a verdict based on evidence that should not have been considered. And they brought, it's for the motion for new trial. And the same as it goes for the motion for a judgment of acquittal, that they should have come to a different way. So when I say we don't like the jury's verdict, I'm not saying, well, they scored a 3-pointer and I don't like the result. It's the process that got us the result that was not a fair game. It's just like the umpire will review and decide that, hey, that guy was out instead of safe, that guy had a first down instead of not, or, guys have the hockey reference, offside or not. Whatever it is, that's just a game, but that principle holds very clearly. We have rules. We must follow them, and I'm not saying we didn't follow them. I'll conclude with this. The judge over in Pinellas County that I appear in front of him a lot of times says, you're not entitled to a perfect trial, although I'm going to try to give it to you every time, okay? So we're not trying to nitpick and say you did wrong or no intent. I got it. But here, this thing that as long as I've been on the case, and certainly as long as Mr. Escobar has been in this courtroom, and I haven't seen all the hearings with Ms. Gowdy, we have repeatedly screamed and screamed and screamed. Please take a look at this evidence as it relates to the police short and how it does not have any nexus other than a coincidence that has a gap. And somehow the jury's going to have to fill in that gap, and they shouldn't have to. I don't know if you have any questions.
Not at this point. I want to listen to the state's response. Just verify that I didn't miss
Yes, sir.
the filing of a written response. Is that correct? There was no written response?
I did not see
That is
one.
correct, Judge.
Okay,
Sorry.
so then I'm going to give them an opportunity to give an oral response at this time, and then give you an opportunity to respond to anything they've said, and I may have some questions for you before I ultimately make a decision in the case. What I will say is I agree with you that all those lawyers that have come before you are good lawyers. I don't necessarily agree with you that they're better lawyers than you. You have well argued everything, including this motion, at this time. So I just want to compliment you on your presentation today. Maybe it's Stetson Law School.
Baby, it's good school.
All
Thank
right.
you, thank you, sir. That means a lot.
All right, let me hear from the state. Ms. Doherty?
Yes, Your Honor. May it please the court, defense counsel.
Yes, ma'am.
Judge, we obviously rely upon our argument to JOA that we did in trial, Judge, as well as we make that argument again. This is just not a circumstantial case. This is a case that was supported by strong circumstantial evidence and strong direct evidence. Defense counsel had said that this was theory supported by no evidence, and that quite frankly is just not true. The evidence in this case that supported the state's theory was there were spent 45 casings that were found at the scene that had a signature to a Glock. A Glock 21 shoots 45s, and the defendant's statement is evidence, and it was recorded, and he admitted to owning a Glock 21 that shoots 45 caliber weapons or bullets. And there was found in his house, based on a search warrant, a magazine, coincidentally enough, that belongs to what? A Glock 45 caliber weapon that he got rid of. You know all of the searches that happened on the Keetley property in both houses, on the property, the entirety of the vehicles, the vehicle that he was driving, all of the vehicles that were recovered, and there was no 45 caliber Glock weapon that the defendant admitted on audio recording to Sergeant Lugo that he owned. That is the murder weapon, and that is evidence. There are 45 spent shell casings that were found. That is the only type of shell casing that was found at the murder scene. And there were projectiles that were found at that murder scene that were 45 caliber ammunition that was capable of being fired out of the Glock. What is the evidence that there was a modification that happened in this case, not based on theory, based on the FDLE analyst Jennifer Clark? The projectiles that were examined had to have passed through a barrel that was not of a Glock firearm. And you also heard from her, it is very easy to modify a Glock firearm with a barrel replacement. So we know, based on the physical evidence from the scene, that there was a modification. We also know from the computer search of the defendant that he had searched barrel replacements. It may not have been for Glock firearms, but there was searches done on his computer that clearly were for barrel replacement, which is the exact type of modification in this case. And a barrel can affect the way a gun appears. Barrels come in all different sizes and shapes. So there is direct evidence that made all of the evidence that came into this case probative and relevant. And so I do want to talk about the police shirt. a month prior to this incident, he is wearing it. That is direct evidence. He has that on his physical person. Law enforcement did an investigation and found a photograph, a Halloween photograph, where he is wearing a uniform. He is dressed up as a cop. It says police. Those are the facts of the case. What is clear is that every witness who could give, surviving witness who could give a statement as to what occurred is that this was a law enforcement, they all believe this person to be a law enforcement officer.
But did they specifically say that the shirt had yellow lettering that said sheriff?
All of them said it was sheriff. Some said yellow, some said silver. So they were not exact as to what the lettering was. But here, what do we all also have that is probative and why that was relevant to this case? We have David Beckwith, who was a witness in this case, who testified and came forward to law enforcement that said that he was friends with the defendant, and the defendant had come up with a plan to dress up as a law enforcement officer, find the people who had robbed him, and make them disappear, to kill them. So all of that is relevant. And so when I want to go back to the defendant's statement, not only did we have direct evidence of premeditation, the way that this happened, we had overwhelming evidence of motive, which is something the state is never required to produce. But we had, in this case, like I've never seen before. This defendant was robbed. We all know the horrific circumstances that happened to him earlier in that year, and that he began an investigation because he was frustrated with law enforcement not being able to find the people who did this. And that he searched, and that with David Beckwith, when he was able to get back into his truck, his ice cream van, and go back out to those streets in Ruskin and Waimama, that he was searching for the person who did this. And we know through David Beckwith that eventually he changed his mind, that he didn't think that it was two black males that did it, that he believed it was two Hispanic males that did this. And eventually he believed it was a person named Creeper. Again, we have tons of consciousness of guilt evidence. We don't just have him changing the vehicle that he used, changing the appearance of it, and getting rid of the 21 caliber, the Glock 21 that shoots 45 caliber ammunition. We also have him lying to law enforcement. That is clearly on the tape. He said that he never looked for somebody named Creeper, that he never conducted his own investigation, and we put six people, and they only mentioned two of them in both of their motions, the girlfriends that were jilted. Yes, there were two girlfriends that were put on the stand that no longer were in a relationship with him. That does not necessarily mean that they are not telling the truth. But what they can account for is Johnny Sanchez, Luciano Alonso, Brianna Gregory, Wesley Smith, Carol Ardono, all of those additional witnesses that never dated the defendant. Mr. Alonso, who just worked at that restaurant and liked the defendant, clearly on the stand was giving him favorable testimony, all said the same thing, that he was looking for Creeper. That is consciousness of guilt, when the defendant purposely lied to law enforcement, knowing that they were investigating this horrific crime that occurred on Ocean Mist. So we have consciousness of guilt evidence. We have the ballistic evidence directly linking the defendant to her homicide, because we have shell casing and a projectile found on his property that is matched to the same gun that killed both of our victims and shot up our other 4 victims. We have a notebook that also proves that he's a liar and that he conducted his own investigation. A notebook with the address and the name, the real name of who Creeper is, with his address written in that notebook with his fingerprints all over it. So there is strong circumstantial evidence in this case. We also have 2 witnesses. That is direct testimony. The main eyewitness in this case, Gonzalo Guevara, who was there, who was present, who has always identified the defendant in that photo pack identification through motions to suppress, through both trials. He has unwavered and has always said and come into court and pointed this man as the person who murdered his friends and shot him and shot his other friends. Judge, as far as his ability to shoot a gun, you heard from 4 witnesses: Norma Jean Towers, David Beckwith, Carmen Smith, Wesley Smith. All 4 of those state witnesses said that they saw this defendant able to fire a firearm after his injuries and prior to the homicide. You also heard from 2 defense witnesses. James Kennedy, who was a witness put on by the defendant who sold him a child's rifle right prior to the murder, had heard the defendant saying he needed that so that he could do target shooting. He was able to fire a gun. And you heard from Dr. Halpern, who, through the direct testimony of a very talented defense attorney with carefully constructed questions, always confirmed that based solely on his right hand, there were a lot of things he couldn't do, including shoot a firearm. But you heard through cross-examination that there was no injury to his left hand, that had completely healed, except for there was a little less strength. But other than that, his left hand was perfectly operational, no limitations to it, just a little bit less strength. We know he can fire a firearm. We also heard from 6 witnesses, that he had a firearm prior to this, the Glock 21, that we could never locate. Stacy Rogan, Carol Ordono, Norma Jean Towers, David Beckwith, Carmen Beckwith, Wesley Smith. And the other person you heard from in a video recording, in his own words, that he owned a firearm is the defendant. He admitted to owning a Glock 21. All of those facts are evidence supported by witness testimony and physical evidence. Those shell casings, those projectiles found at the scene, those spent shell casings found from Wesley Smith that he collected after target practicing with the defendant, as well as the projectile and the spent shell casings found by law enforcement from the vehicles on the Keetley property where the defendant would practice target shooting, matched the ones found at the crime scene. All of that is physical evidence linking the defendant to this homicide, supported by an overwhelming amount of evidence showing motive. So we ask that you, again, deny their motion for judgment of acquittal and deny their motion for new trial. The jury in this case found that those victims and those eyewitnesses were credible and that they were telling the truth in this case.
Ms. Doherty, just like Mr. Grant well argued, one of the things that I find common in these serious cases that I try in this courtroom is the caliber and quality of the attorneys on both sides. So thank you very much for your argument. Let me see if I don't have any questions of you at this time. Let me see if Mr. Grant has any response or anything additional.
If I may have just a moment.
Yes.
Not much of a response. There's a strong argument by the state. I feel like bringing a jury back and having a good closing argument. Like I could do it this time, right, to participate. But what I would say to that is there are certain things in there that I would disagree with. When she, for example, said Carol Orduno said it was a .45, my recall of the evidence was that she was not that clear. So there are some factual discrepancies.
Well, let me ask you, and I apologize. I know how much I would hate it if I had a response I planned to get up and then the judge cut me off and changed avenues. But one of the notes I made that I thought was important was the plan that Beckwith testified to regarding dressing up like a law enforcement officer and whether that in fact would open the door to sheriff, police, security, any type of shirt that has law enforcement. Did Beckwith not testify that the defendant had discussed with him a plan to dress up as a law enforcement officer?
Beckwith did testify to that, but to the question...
Well, that's evidence.
That is evidence. He was also quite the character, as we recall, which the jury can consider. I know that's your next comment.
Exactly. It goes to the weight that the jury gives it.
Weight versus admissibility. But here's the answer to your question. Can they listen to David Beckwith when he wasn't rolling around on the ground and doing everything that he did over the course of the time with Mr. Escobar in cross-examination. Can they listen to him? Can they watch them? Can they evaluate him, decide whether to believe some, all, or nothing of what he says? The answer is yes. You know the jury instructions better than I do on that. But here's what I would say. I go back to that time where we were arguing, and hey, is this admissible evidence? Is this admissible evidence? Is this his testimony is admissible evidence, but it doesn't go to the link to say, oh, great, now we're going to bring this police shirt in. Okay? David Beckwith, you stated his testimony, but let's state what his testimony was not. There were not specifics about that. Right? There were not, here's what we're going to do. We're going to get a black shirt. Right? That's going to say sheriff. Okay? Here's what we're going to do. We're going to make sure that you don't do something stupid like wear a police shirt to make this a reality, right? David Beckwith also put a gun to Michael Keetley's head, and something in him, fortunately, made him decide not to pull the trigger, because he was going to blow his brains out. That's David Beckwith. David Beckwith did not say a word until David Beckwith got a deal. And what deal did he want? He wanted immunity, okay? And I get that. That's all for the jury. Is his testimony suspect? Yes. Okay? Could the jury have given it some credibility? A lot of credibility. I have no idea.
They may have given it no credibility.
Correct.
They still could have convicted Mr. Keetley in this case on the ballistic evidence and the fact that he got his car painted the day after.
Let me address that in a moment so I don't miss the point, because you just made it for me. They could have decided based on nothing that Beckwith said. And if that's the case, you've got the answer to your question. When I have this testimony, does that not make the police shirt and evidence and picture more relevant? No, it doesn't. If that is evidence, if that testimony can be considered before the jury, I argue that it can. Okay? And if that testimony is subject to scrutiny, I argue that it was. Okay? The jury can do with it whatever it wants. It doesn't change the fact about this police shirt. They are wholly separate. In fact, when I mentioned that there are gaps, that's a gap that they're going to fill in that really is not reasonable in itself. You mentioned the van, okay? I think you said you painted the car. It was the bottom of the car. It wasn't the whole car, you know? And it was done on a Friday when nobody's really working, okay? When he was able to take advantage of a friend's opportunity and time, okay? So I get circumstantially that may look bad. I got it. A trier of fact can determine that. But again, there's an other explanation for it that the jury can decide. My point is, if they're going to your question, if there is evidence of painting the van the next day, that still doesn't make the police shirt admissible. It still doesn't tie in. It goes back to my very point that if they have evidence that they can put forth that I can't do anything about because it's admissible under the rules of evidence other than argue against and challenge, I can do that. But they went further and beyond. Sometimes you stop them, like I said, when we argued the burn pit and that cloth, right? Sometimes you didn't with the police shirt, okay? You think about it this way, what I would suggest respectfully. Could they have made all those arguments about the van being painted the next day without the police shirt? I think the answer is clearly yes. Clearly yes. And could the jury have decided on that? The answer is clearly yes. Could they have considered that David Beckwith, why would you want immunity from a deal if you've done nothing wrong? That's a question I still don't know, even after the verdict. Could they have decided and evaluated his testimony? Yes. Without the police shirt? Yes. Does his testimony make the police shirt relevant? No, because he did not give one detail about some type of, I think she said, she being Miss Doherty said silver. I kind of took it as like that glow color or whatever. You know, it's kind of either yellow or gold or something, but it certainly wasn't white. Nobody ever said white. Nobody ever said police, right? And so whatever Beckwith testified to, I would concede. If Beckwith said, here's what we're going to do, and it's going to look like this, and you're going to have camo pants, and, you know, if he had more details that comported with the crime, maybe so. Okay? The ballistics evidence, you know, I did note when Ms. Doherty was arguing that she said Carmen Smith testified to things that I don't think Carmen Smith did. I think her testimony was a little bit of a wash about whether she saw things. But again, that would be a question for the jury. We had an explanation that we think is reasonable, led to reasonable doubt. We understand that the jury did not get there. Again, I'm not saying I want to take my ball and go home because it wasn't fair. Okay, I like this jury from the sense that for 3 weeks they were alert and they paid attention. You know, I like that they did their job. I can disagree with their verdict, but that's not the point. The point, again, is as it relates to the ballistics, there was another explanation. And Wesley Smith, collecting and the circumstances of how that bag was turned over to Lugo, you remember all those facts. I don't want to go into them in detail. So it's not like it's in lockstep. Okay?
I thought the defense did a great job of raising issues with all of that. But as you said, at the end of the day, that's a question of fact for the jury, and they made their determination. Now, we don't know. We can't go back and exactly what they disregarded and what they put, majority of their weight on. But
right.
At the end of the day, they found no reasonable doubt and found him guilty of all counts.
And that's why I like talking through these things with you, because we are in lockstep on this. It always makes me chuckle when someone gets a verdict, and whether they're the knuckleheads on a computer or whether they're in the gallery or whether the attorney ourselves, they say, well, this is when the trial was won and this is when the trial was won. We have no idea if they convicted Michael Keetley in spite of David Beckwith, let alone, we just don't know. Okay? So I get that. My whole point, though, is what they got to keep was not proper. That's the point. As it infected, I think, the process by which they could think through. Okay? Again, I know I'm repeating. They can prosecute on admissible evidence, not on admissible evidence. And I think when they had 4 or 5 things that were of value for a jury to consider and of value for us to fight back on, that 6th thing or that 7th thing, trying to go that extra mile, what's in the trash bag, a modification. I get that Ms. Doherty is making a good argument as to why they thought there was a modification. There just simply is no evidence of it. There simply is no evidence of it at all. It's just as likely that someone could have used a .45 handgun. Maybe even 2. I don't know. What we know is these poor fellows were shot.
But the state is entitled to theories based on what evidence there is, and there was evidence of computer searches for different barrels. There was evidence that what the witnesses saw was clearly not what it appeared to be, a shotgun.
I'm glad you brought that up, because I knew that I was forgetting something. It's in the motion. If I don't mean to be hitting Miss Doherty. If you want to hear from her, terrific. Computer searches. Okay? What do we hear about the computer searches? I don't have the transcript right in front of me now. But in their opening statement, the prosecutor said, 3,000 searches for this and 11,000 searches for this. Whatever. High numbers. Okay? And then when we cross-examined Connie Bell, when Attorney Khan got up and cross-examined Connie Bell,
it was a great cross-examination.
Oh yeah, I was supposed to do it, and I got the pleasure of watching it, right? Because she had it spot on, and it was 0 here. It was 0 there, right? The numbers that the prosecutor suggested in their opening statement were just not true. Now, I want to specifically say, I don't think they misled the jury in their opening statement. I just don't think they understood their evidence, right? And that's why cross-examination took place, okay? But here's the thing. Everybody wants to give the closing argument. I always wrestle for the opening statement because that's primacy. And the state of Florida gets to come up first. And they get to say what the evidence will be from their end. And I get to say what I believe the evidence will be from our end, right? And in the first thing that the jury heard factually, the state of Florida, intentionally or not, they misled the jury and said there were a number of searches that just simply were not true. Now it's burned in their
But
head.
we know that happens. You remember in law school, we went to law school together. What were we told about opening statement? Don't make promises that you can't fulfill. Why? because it questions your credibility. So we know it happens. They teach it in law school not to say things that during the course of the trial are going to turn out to be wrong. So that's not a nuance to this case. In fact, you're warned not to do it because it's going to hurt the credibility of your case.
But even more so, it not only could hurt the credibility of the case and have you be seen in a bad light for the juror. I agree. I remember it being said, don't write checks your mouth can't cash. And that's what happened in this case, because now it's more than just potentially a trust issue between juror and advocate. It's more than that. It's now that the jury has heard things that are not true. Okay? And you take 3 weeks. How many times have we even had a readback in this case? How many times? Dude, these guys and gals are taking notes left and right. And they go back there over 2.5 days. And I've never been in a real jury room, but I've been in a fake one before. And we're like, hey, this is what the witness said, or that's what the witness said. And we argue. You and I could be on the jury back, and you said, no, he said this, and I said that. Well, let's go to the judge and ask for a readback, right?
Happens all the time.
And sometimes opening statements, and this is I got it, it's a danger of the jury. Sometimes opening statements are accepted as fact, right? And that's why, quite frankly, in Trial Advocacy 101, they teach you, say it and watch, check it off. Hey, that's what Mr. Grant said would be in the opening statement.
But there's case law that says, and you can correct me if I'm wrong, that
Yes, sir.
the law presumes that the jury can follow instructions. Otherwise, this whole system is turned upside down and it's worthless. The
Right.
law presumes the jury can follow instructions. And the jury is told what about what the lawyers say,
Is
both
not
in
evidence.
opening and in closing?
Is not evidence.
Not evidence.
Correct. I understand.
And you're not to consider it as such.
But that should not give license to an advocate telling a jury something that is simply not true. And again, underlined bold font, as I did before, I am not saying that the state of Florida said something intentionally incorrect or directly misled the jury. But there was a misleading there. And that's why the computer searches were an issue, because a component of their case in this largely circumstantial case, and I think Ms. Doherty and I agree, there's direct evidence here, but the computer searches just were not what they said they were.
Okay, and assuming I accept that, where is the authority that is on point that says the prosecutor over-promising in opening statement is grounds for a new trial?
It's in my motion for new trial. It's in my judgment of acquittal. It gives you the standard that you can consider and apply to facts. That's where it is. I don't know of any case specifically, and I remember being back in law school and learning that thing. And when we were mock prosecutors or mock defense attorneys, and they said, hey, Grant, you just said something that's not factually correct. I'm like, well, what happens then? Sometimes it would be a mistrial. We didn't really know. And I don't know that the case law has affirmatively, that I'm aware of at this point, said this is what happens when a prosecutor says something that is not evidence, but is contrary to the evidence. It's misleading, however you want to phrase it, right?
Was there an objection made when those misstatements were made during opening statement?
No, and I can say I did not object, and that would have fallen on me. We were still, in the process of learning exactly how the computer issues were made at the time. And I don't like just to make an objection and say, ouch, that hurts, or I don't like it. I experience that all the time. If I'm not getting 4 objections in my opening statement, I have done something wrong. I think you gave me 5, right? And so I did not want to object willy-nilly to that, as we had to take another deposition, as you recall, Ms. Kahn and I did during one day with Ms. Bell, and that's where we learned further and confirmed further how this computer search worked, and you saw the product and the fruits of the labor that our team did when Ms. Kahn did a great cross-examination. So the answer is no, and I gave you why. And that's significant, right? And that's significant, again, because I understand they say, hey, this guy has said, from the beginning, Mr. Guevara has always said, and I'm not going to go through the cross-examination that I did of him or that Mr. Escobar did of Lugo in those circumstances. Those are all things that can be considered. But I think we all agree that while Mr. Guevara, as an example, always said it was him in court, he even went further. Different height, different size, different weight. All of that can be considered. But it's not like this is direct evidence that is just, staunch, right? There are questions of it, and that's why the circumstances involved that kind of help maybe buttress those identifications. And again, what we're doing here is speculating, because you and I were not on the other side of that jury room door. I got that. We're just saying what the jury was allowed to consider was not right and proper in these specific instances. And I do appreciate you bringing up the computer searches, because I did not hit that in my first response, or my first argument.
No, I just saw that it was one of the things in your motions that, certainly had my attention.
Yes, sir. I have nothing else unless you have questions to me. And, of course, if Ms. Doherty feels like she needs to respond to that issue that I did not address, I would obviously defer to the court and ask her to add that opportunity.
All right. I don't have any questions. Ms. Doherty, did you have anything additional?
Judge, only that I agree that opening statements are not evidence, and I did cover the computer searches in closing and said that the only relevance was to show the defendant's sophistication and knowledge of firearms, and that he had the skill set and the knowledge base to be able to modify a gun, and we never went beyond that. So, Judge, I do agree that the opening statement is not evidence, and so that should have no bearing on these motions that you're hearing today.
But you would also agree that just because it's not evidence, it's not a green light to intentionally mislead. The defense, Mr. Grant, has acknowledged that it was not an intentional misleading, but
correct,
it's not a green light to say anything you want in opening statement.
And we were careful with our closing argument and never made those arguments again in closing, Judge. So that was not
Which
a
is
basis.
also not evidence. Though.
Correct, Judge.
Closing.
But again, I just wanted to reiterate that we did mention the computer with a very limited relevance, and why we believed it was admissible, and we stayed away from the number of searches and all of that. That was not mentioned at all in closing.
Do you acknowledge that the cross-examination did seem to indicate that there was a discrepancy in what was presented to the jury?
Judge.
And
100%. Yes.
All right. Thank you.
Thank you, Judge.
Anything else, Mr. Grant?
The brief response, when they say they didn't mention it in closing argument, it's kind of like Williams rule evidence, that sometimes you let it go and it's like a bug bomb. You don't acknowledge it, but the stink is still there. Sometimes when they say something that's not correct in the opening statement, it's already infected the trial. Right. And it's not that they said something necessarily that was not evidence per se. It is. As they said something that we were able to conclusively show that was not true.
All right. Obviously, I've listened, and again, I want to compliment both sides. First of all, the defense writing of the motions. They're well organized, well written, and I appreciated that. They were a good read. And the arguments today from both sides. Again, the quality of the attorneys, the caliber of the attorneys is certainly noticed. I'm certainly going to miss that in not doing these types of trials anymore. These serious, very emotional trials, but all of which have in common the fact that the attorneys are the highest caliber attorneys that I see. And they make things difficult when I have great arguments from both sides. But I have given it thorough consideration, and I am just not convinced. I recognize that I could be wrong. And I sleep well at night knowing that the appellate court will have an opportunity to review. A panel of 3 judges will have an opportunity to review any decisions that I've made or any of the other decisions that other judges have made in this case prior to my trying the case. And that any appeal of any of those decisions will be well presented and well argued by the defense. And I'm not offended if the appellate court says, you know what, you shouldn't have let the sheriff's shirt in. But as I sit here right now, I'm just simply not convinced that the rules of evidence prohibit, particularly when you have testimony of Beckwith, who says there was a plan of dressing up as law enforcement, and lo and behold, a shirt was found, whether it be police or sheriff, that is a term related to law enforcement, that shirt would be prohibited. I'm not convinced that the difference in color, and for example, if an eyewitness said that the shooter was driving a green Camaro, but in fact the investigation showed that the defendant, who was ultimately charged in the crime, had a red Trans Am that looks like a Camaro, that the jury wouldn't get to hear that because there's the possibility that the witness's description was wrong. I just have never encountered that where it's not. Or for example, the other analogy I came up with, if the eyewitness said that the shooter was wearing a chimpanzee suit, but in fact a search revealed that the defendant had a gorilla suit, that the jury wouldn't get to hear and see the gorilla suit, even though a chimpanzee and a gorilla are different, just like a sheriff and a police, but somewhat related. They're in the same family. They're in the same category. Police and sheriff, gorilla and chimpanzee. But so that's my ultimate position on those things. And as I said, I may be wrong. And I accept, if the appellate court accepts that I was wrong and says that there was certain evidence that should not have come in, and they reverse. But I respect the jury's finding. I don't see anything. I know there's a number of other issues. There's a list. There were a lot of legal issues that were discussed today that have come up and that are listed in these motions. But I don't see anything that warrants me granting the motion for new trial or the motion for renewed judgment of acquittal at this time. So I am going to deny those, both of them, and we're going to proceed now appropriately to the sentencing. So at this time, I'm going to turn to the state and ask if they have any witnesses and if they have any presentation they want to make related to the sentencing.
Your Honor, I'm very sorry for the interruption. May I make one comment, not on your ruling, just to make sure when you said, I just want to make sure that I am there, when you said the prior rulings, we obviously want to make sure that all prior objections, motions are preserved.
Absolutely,
for the record.
yeah.
We raised those.
I respect that.
Thank you.
And same rulings
Yes,
on
sir.
anything that came up previously, but they are preserved for the record.
Thank you, sir.
Ms. Doherty?
Yes, Your Honor. Judge, I did prepare a score sheet that I had emailed you as well as defense counsel.
I have a copy. Mr. Grant, do you have a copy?
What Ms. Doherty did was send that score sheet to us. She showed me this morning that she wanted to put on your desk. It is the same score sheet she gave me, so the answer to all is yes.
Okay.
And Judge, I do have some next of kin as well as some of the victims that do want to address the court. Judge, Ms. Casada, who's the mother of both of the deceased victims, is present, and she will need the assistance of a Spanish interpreter.
Do we have an interpreter present?
We do, Judge.
All right. Well, let's bring her and the interpreter down. What I'll do is I'll put them at the podium. I will allow you to, I'll swear them in, both the interpreter first and then the witness, and then I'll allow you to ask any questions or present their testimony however you deem appropriate.
Judge, I think she is just going to
Make a statement?
address the court, and we also have our victim assistant, Stella Carabine.
All of them are welcome, and if they all want to kind of get around that microphone, make sure that the green light is on the microphone. All right. Let me start with Madam Interpreter to swear you in to translate. Do you swear to accurately translate from Spanish to English and English to Spanish in the proceedings this morning?
Yes, Lisette Corsa, State Certified Spanish Interpreter.
Ms. Corses, thank you. Now I'm going to swear the witness in. Ma'am, if you'll raise your right hand, please.
Señora, le pido que alce la mano derecha, por favor.
And if you'll state your name for the record.
Diga su nombre para el acta.
Paz Quesada.
Paz Quesada.
Ma'am, do you swear or affirm that any testimony you offer
Testimonio que ofrecerá
will be the truth,
será la verdad,
the whole truth,
toda la verdad,
and nothing but the truth,
únicamente
so
la
help you
verdad
God?
de Dios?
Yes.
Yes.
Thank you. You may put your hand down.
Bajar su mano.
I understand you'd like to make a statement today, ma'am.
Presentar una declaración en el día de hoy, señora.
Yes.
Yes.
All right. You may proceed, and remember that she is interpreting for you, so give her an opportunity to translate. So break it up so that she can translate.
De interpretar con pausas.
Okay.
You may
Okay,
proceed.
puede proceder.
Bueno, mi pregunta para él, lo que siempre he querido preguntarle,
Well, my question to him is one that I've always wanted to ask him.
¿por qué mató a mis hijos?
Why did you kill my sons?
Y quiero preguntarle cómo se siente, si siente su conciencia tranquila o qué es lo que él siente si no se arrepiente.
And I wanted to ask what he feels, if his conscience is clear, or what does he feel if he's not sorry for what he did, remorseful for what he did.
Me quitó la mitad de mi vida.
You took half of my life away.
Me destrozó mi corazón
You-
sin mis hijos.
You tore my heart without my children. You destroyed my heart without my children.
Mis hijos es lo único que yo tenía. Los amaba y los amo con todo mi corazón.
My children were the only people that I had. I loved them with all of my heart.
Y quiero saber cómo él se siente.
And I want to
Vermelos
know
quitado,
how you feel now that you've taken them away from me.
sabiendo que eran unos muchachos inocentes y no le hacían daño a nadie menos a él.
Knowing that they were innocent young men that had never caused harm to anyone, and less to you.
Siento por culpa de él, no pude ser abuela, ellos no pudieron seguir su vida, hacer su vida.
Because of you, I cannot be a grandmother. Because of you, they couldn't continue with their lives.
Ellos tenían mucho futuro por delante.
They had they had a big future ahead of them.
¿Cómo se siente con el daño que me hizo a mí y a todas las familias?
How do you
de
feel
las víctimas?
with all the hurt that you've caused me and all of the victims' families?
Si no se arrepiente.
I want to know if you're not remorseful.
Esperé mucho tiempo esto y no me arrepiento de haber seguido por 12 años, más de 12 años hasta el final.
I've followed this for so long, and I'm not sorry for having withstood through it all for 12 years.
Pero lo que más siento y el consuelo que siento
But what I feel the most, and the relief that I feel now,
que nunca va a salir y no va a poderle hacer daño a más familias, va a
That-
lastimar más personas como me lo hizo a mí.
is that you will never get out, and you will never be able to hurt any more families, or cause the hurt and the damage that you have caused me.
Espero que nunca salga.
I hope you never get out.
Salga,
I hope you never get out,
y que siempre lo tenga en su conciencia.
and that you always carry this in your conscience.
Es todo, ya no puedo hablar.
That's all. I can't speak anymore.
All right, let me see if the defense has any questions.
Oh, no.
Thank you, ma'am.
Thank you.
Ms. Doherty?
Judge, the state calls Frankie Cantu. He's brother to Richard Cantu.
Mr. Cantu, if you'll come forward, please, to the microphone. Ms. Doherty, do you wish to ask him questions or him to simply make a statement?
Just to make a statement, Judge.
All right, Mr. Cantu, if you'll come up to that microphone and raise your right hand, please. You swear affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, sir. You can put your hand down.
Just want to know, how could someone do such a heinous crime to 6 innocent men? You know, it's hard to go through this 12 years to finally get justice for our family. It's you know, the physical damages are always going to be there. With my own brother, Richard Cantu, he has physical damage. I see it every day. It's hard to see that, you know. The emotional damages always going to be there. You know, with 12 years, we've been waiting for this to come to where we're at now, and it's, you know, from my aunt Boss, you know, her 2 kids were taken away from her at such a young age. You know, you know, I went to school with them, and I absolutely love my cousins. You know, to see this happen to that, it's unbearable, and I don't, you know, it's even for my love families, the Ramon Galan, like the time that it happened, it was like unthinkable to have this happen to families and friends. Yeah. It's a heinous crime out of hate and hatred for whatever reason, and no family should go through this ever.
And here we are 12 years later, finally, hopefully getting justice for our family. Sorry. Have any questions?
Let me just see if the defense. Thank you, sir. Ms. Doherty?
Judge, the state calls Gonzalo Guevara.
Gonzalo Guevara. If you'll come forward, sir, to the microphone. And when you're ready, if you'll raise your right hand. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Put your hand down. Actually, state your name for the record, please.
Gonzalo Guevara.
All right, you may proceed, sir.
I really don't know what to say. I didn't write nothing down. I'm just going off of it. I just want to know why you took them. Like, you took two good people. You were a coward that night. You hurt so many people. You hurt this lady losing her two kids. We know what you did that night, and you know what you did that night. You hurt us. You caused so much pain to everyone involved in it. And the way you're showing yourself in this courtroom shows the person that you are. They say forgiving people helps you heal, but I can't forgive you. You took two really good people away from this world that were doing the right things in life. And that hurts a lot. That's all I'm going to say.
All right. Anything from the defense? Yes, sir. Thank you, sir. Ms. Doherty?
Daniel Beltran.
Mr. Beltran? If you'll come down to the microphone, sir, and when you're ready, if you'll raise your right hand, please. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes, sir.
All right. If you'll state your name for the record.
Daniel Beltran.
All right, you may proceed.
Well, that's all the damages and all the stuff that barely I just heard with it. All that is true, and all the damages that it did to me, to all my friends, especially to the mother of the Surgeon Juan. I want to tell him though that I forgive you what you did, because I know it's not you, it's the devil in you, and you should let go of that. You should ask God to forgive you. Because you ain't escaping none of his wrath. Not even the human's wrath you just heard. I would just like to tell you to ask God to forgive you. Maybe you can find forgiveness and then live a better life as to eternal life. So other than that, you're going straight to hell. And I ain't escaping that. No matter how many years or whatever it is your sentence that they would give you, if you don't ask God to forgive you, you're going to hell regardless. And I've been seeking for God ever since you did what you did to me, because I know he has a purpose that he left me alive. And I like to share that with you, because yeah, in order for me to get forgiven for what I did, whatever I have done, no matter what level it is, I know I gotta forgive you in order for God to forgive me. So I forgive you, because I care about my salvation and the way that I be in front of God. Hope you do too. God bless you, brother. That's all I can say to him.
Anything
Thank you.
Thank you, sir.
Judge, that's all of the family members that wanted to speak and all of the victims.
Okay. What I usually do is then see if there's anyone from the defense who wants to speak, and then I'll listen to, as we know, the sentences in this case, some of them are mandatory sentences, but does the defense have anything that you want to present by way of testimony at this time?
Well, to kind of be non-responsive, let me address what we just heard in the words. I know that these family members have asked questions. And I know that Mr. Keetley wants to address the court. However, he has attorneys and there are appeals. And so we have advised him that he must remain silent. So his lack of communication is based on this process moving forward. He has, and he always has maintained great sorrow for what's happened in this case, but he of course has maintained he is not the one who's done that. I don't believe there are anybody to speak. His parents are here. His sister is here. Do any of you want to address the court?
You're welcome to if you want to come down.
No.
Okay, I need your name for the record, though,
Yeah.
ma'am.
I just want to say
Wait, let the attorneys want to talk to you.
We don't have anything.
Okay. Let me turn back to the state regarding the request for sentencing and the required sentence and minimum mandatories that apply to any or all of the charges.
Judge, obviously the first two counts, the first-degree murders, those require a mandatory life sentence. There also is a 25-year minimum mandatory for the discharge of a firearm resulting in death. As to the 4 counts of first-degree premeditated murder, there were also findings of a firearm discharging resulting in death. All 4 of those counts require a 25-year mandatory minimum. Judge, we are asking for life sentences in all 4 of those counts based on the egregious and horrific nature of these crimes.
Okay. And I do have the score sheet that you've presented. Mr. Grant, you've indicated that you reviewed that score sheet, and I'll give you the opportunity now to be heard regarding the sentence.
We understand that there is no discretion that the court has, and so we understand that you are about to impose a life sentence.
Well, as to counts 1 and 2. There's some discretion in 3, 4, 5, and 6, anywhere from 25 to life.
That's where I was going to go next. You do not have to go above 25. The 1020 life law gives you the discretion of 25 to life. Judge, he is going to be getting 2 life sentences. We would ask that you sentence, if you take into account the circumstances, assuming for purposes of argument the state's position in this case. Mr. Keetley was a victim of a horrendous crime. He has significant, fortunately they're better, but he has significant physical difficulties. He has been the victim of attacks in the jail, such that now he's in solitary for his protection. I would ask that, given the fact that the court has to do 2 life sentences, 25 years for the remaining counts would be appropriate, given what I've indicated, as well as his lack of prior record. I do not say that in any way to devalue those victims who fortunately did not die. And as Mr. Beltran just eloquently said, there is a purpose, and this man seems to want to fulfill that. But notwithstanding that, 25 years would be appropriate in that case.
All right. Thank you, Mr. Green. Anything else, Ms. Doherty?
No, Your Honor.
All right. Mr. Grant, just want to have you verify that the score sheet, was there anything related to that? Did you have something else?
No, sir. The answer is yes. I have verified the score sheet. No, I don't have an issue. It does show no prior record. It does give severe injury points for 3 times and 40. It does do moderate for one of the other victims. The math is correct, and the bottom of the guidelines is correct. I understand there's the mandatory penalty, but it looks like 300 months would be the bottom of the guidelines.
All right.
So no issue there.
All right. Do you know how many days? I know it's very significant, but as part of the sentence, I will have to put on the record
Yes, sir.
how many days he has been in the county jail.
I will pull that up right now. What's the date of arrest again? Is it December? I will correct that. Yeah. Judge, what I have from the time and date calendar would be 4,559 days credit. I routinely ask, and I understand there's not a legal basis for that, I routinely ask for 30 additional days of credit because there are often times where a judgment and sentence or other paperwork delays. If the state objects, I know he does not get that credit time, but given the sentence, I would ask the court to consider that.
Yeah, I usually round up to avoid any, like for those reasons, motions for additional credit. And those come about for different ways. I don't know if he had bonded out or anything. I know there was a bond, but he had never bonded out, so he has been in custody the entire time.
Yes, sir. It's been continuous.
Yeah. Ms. Doherty, would there be any objection to rounding up or giving an additional 30 days to the 4,559?
No objection, Judge.
Okay. Great. That requires me. That's going to be 4,589.
Yes, sir.
Thank you. I can do simple math, at least. All right. Go ahead, Mr. Keetley. Let me have you stand to receive the sentence. I know that it's not a surprise that you're going to be sentenced to life today, but I do want to make a couple of comments. This has been a very long road and a very difficult case for a number of reasons, including the fact that it has been such a long road. I think that it is the oldest case that is on the docket in this circuit, but it has finally come to an end, and what it shows to the victims in this case is that justice is not always swift, but justice is eventually served. Nothing I can do or say today will alleviate the pain that you have suffered and the losses that you have suffered, but I do hope that you can find some peace in the conclusion, or at least the conclusion at this stage of this case after such a long road. I am going to adjudicate, if I haven't previously done so. I may have. I probably did adjudicate at the end of the trial. Madam Clerk, was he previously adjudicated?
No, he wasn't.
All right. Well, I will adjudicate Mr. Keetley at this time guilty on all 6 counts. I will sentence him to life in prison on each and every one of the 6 counts, with a minimum mandatory of 25 years in each and every one of the counts. In Florida, life means life because there is no possibility of parole. So, Mr. Keetley, you will, barring any reversal on appeal, spend the rest of your natural life in the Florida Department of Corrections. I am going to impose all standard fees, costs associated with the standard computation of those fees and costs. You will have 30 days to appeal the judgment and sentence entered against you. I will give you credit for every day that you have already served during this long road in the Hillsborough County Jail, which was 4,559 days, but I'm going to add 30 days to give you credit for 4,589 days. Is there anything else from the state?
Judge, you do need to announce formally on the record if those life sentences are to run concurrent or consecutive.
Absolutely right, and I am going to run them concurrently.
Thank you, Judge.
Is there anything from the defense?
I'm going to defer to Mr. Escobar.
Mr. Escobar.
Yes, Your Honor. We have been hired by the family to handle the appeal, and so we will file the appropriate papers by Tuesday.
Excellent. I appreciate you letting me know, because there's sometimes we're not sure what's going to happen and whether we need to appoint the public defender or anything, so I do appreciate that. And I have announced on the record that there he does have 30 days to appeal.
Thank you, Your Honor.
You're very welcome. Thank you, and nice to see you.
Nice to see you.
All right.
Judge, I'm sorry. I'm speaking with Mr. Keetley.
Yes.
A question.
Yes.
He had a question when you pronounced court cost. I told him those were the statutory court costs.
Right.
Those are not costs associated with the prosecution.
Well, I don't have the list up here of the state, but I will tell you this, that if you have a discrepancy with any of the standard court costs that are imposed, feel free to file a motion, and we will have a hearing. I am not imposing. I know that he was at some point represented by the public defender's office. I'm not imposing, because he was majority of the time represented by private counsel. So I'm not imposing those costs associated with public defender fees. So I will strike that from the standard costs. But if you have any issues regarding costs, I welcome you to file a motion.
We will review the judgment and sentence, of course, and if there's a question, we'll follow up on that.
And it'll take a couple of days. I don't expect to sign that until probably Monday. I don't expect that it'll be in my queue to sign today. And he won't be transported until after that.
Okay.
All right.
Thank you, sir.
You're welcome.
Your time, nothing else.
All right. Thank you. Thank you. Thank you, everyone.
Judge?
Yes.
Don't sign that one. You need
Don't
to-
sign this one? Oh, there's one in Jaws? Misty, I was going to sign this one, but Christina says there's one in Jaws, so I'll sign the one in Jaws. And let me know if there's anything else. All right.
Judge, do you want us to upload this photo as well?
She said there already was one in Jaws.
It's already uploaded.
Okay.
Check. If it's not, I can sign this one.
I saw it. Yeah, absolutely. You can go ahead and sign that one, and I'll delete the one out of Jaws.
Okay.
Judge, and I just need to make a mark on the last page on your signature page that it's prison and life on there. Otherwise,
I did.
for some reason, it doesn't get counted. Oh, perfect. Thank you.